Welcome to the Dubio podcast. The following is a conversation with David Young, a highly accomplished barrister and international criminal defense counsel, having acted as such in high-profile terrorism and organized crime cases back in England, as well in high-profile cases in various international criminal courts. He successfully led the defense of Assad Sabra in the Hariri assassination case before the Special Tribunal for Lebanon in The Hague, who subsequently was acquitted of all charges. He was also the lead counsel for one of the four accused charged with war crimes and crimes against humanity before the Kosovo Specialist Chambers in The Hague from 2020 to 2023. David is currently back in the English courts, staying at Red Lion Chambers in London. The conversation was very interesting and I hope you enjoy. Don't forget to follow us on YouTube and Spotify, as well as on LinkedIn and Instagram. Thank you very much for coming.
A pleasure. Good morning to you.
Good morning. So, let's start right away. I wanted to know a bit more about your start in criminal law. How did you get to become a barrister?
Sure.
What made you come through?
Well, it was a long time ago now, but I started back in 1986 when I was called to the bar in London, and I went to the Middle Temple, did the bar exams, then started in commercial chambers, and then eventually found my feet in a common law or criminal chambers. So I was on my feet from about 1987, acting as a barrister in the courts in England and Wales. And then it started from there, really.
But what made you become a barrister and not a solicitor? Because nowadays everybody chooses to.
That's right. Well, a lot of people seem to either go become a solicitor, then change to barrister, or vice versa. At the time, that didn't exist. So there was you were either applying to be a solicitor or a barrister. And on the television at that time, there was a program about barristers in Crown Courts, which I absolutely loved. So I thought that's what I want to do. So I realized from a very young age, I wanted to do that and speak in court. And so it was very simple. I knew what I would try to achieve. So I started that way.
Okay, that's easier. It's
easier, yeah. These days it's often very difficult when you're at university, and often people say, well, I don't know what I'm doing. I'm doing a degree, but I don't know what I'm going to do thereafter, unless you have a specific plan in mind. But yeah, I had a specific plan in mind, and I was lucky enough to have a chance to start my career in the late 80s.
So, and you started with criminal law, and what kind of cases in the beginning?
Well, it was what's called a common law chambers. So the chambers tend to do some civil law, some criminal law, and the criminal law was general crime. It was general crime. So we started off doing minor dishonesty offences, minor violence, the usual sorts of criminal cases like shoplifting, minor assaults, burglaries, and that sort of thing. So, and that's a good way to learn. So what you do in your second 6 months, it's called, as a barrister, because you have to do 12 months pupillage or apprenticeship overall. And you basically learn your craft by doing literally hundreds of trials. And through that experience, some work, some doesn't. And you learn from your pupil master and those in court, and you learn the skills of the advocate. And you literally do trials every week, every day. And so you very quickly learn to become an advocate. And then as you do more and more cases, you tend to do more serious cases. So you start literally at the very bottom, and then you work your way up if things go well.
Unfortunately, here in Portugal, there's no distinction between solicitors and barristers. It's the same. You become a lawyer and you can do both. And the traineeship, you don't have that practical side. You need to intervene like 5 times, but never alone and never with responsibility. That's
right. Yeah, I think it's good to have what's called a pupil master or pupil supervisor, because they act as a mentor and a role model. So you try and learn from their skills, and also you learn from others in the chambers that you belong to. So you pick up a lot from just simply doing the job and following others and trying to learn the job by watching them, listening to them, and working in the courts. And you learn that way. And unfortunately, that's a kind of a skill and that you can't learn remotely, in my view. So I think it's like a doctor or a nurse. You have to be very hands-on to learn the skills, and it's often very difficult to perform these skills remotely online. So I would urge budding lawyers to get into court if they want to do that kind of work and to learn for themselves. They'll have successes, they'll have failures, but they will learn. So they'll get better for it.
What was the more difficult case when you were a pupil? And
Well, it was all difficult because I wasn't I had no experience. So when you're a pupil, literally the clerks who organize the chambers, they could send you when you've done 6 months to literally any court. So it could be a magistrate's court, or it could be a high court or the Court of Appeal. I remember finding myself when I was about 2 weeks experience in the Chancery Court in the High Court in London, and I had no experience of Chancery law whatsoever. So you have to learn things very quickly to survive. And so I would be defending, prosecuting, and often if I was prosecuting cases this was when the Crown Prosecution Service was starting, I would be given like 60 or 70 files, and each one was a new case. So to try and get on top of 70 cases when you got the cases 30 minutes before the court starts is quite a thing.
yeah.
Often you were learning the case, picking up the file as the usher called the case on. As you literally, as the defendant walked from the back of the court to the dock, you were picking up his file. So that was an experience, but it's all good experience, and I would urge all good young lawyers to try as much as they can and gain as much experience when you're starting out as possible, and then you'll find which area of law you're interested in, what you don't like. And when I started, I was in a commercial aviation chambers, and I quickly realized I wasn't really very interested in doing paperwork. And when I got into court, I very much enjoyed it. So
Yeah, I understand you. My second seat in my traineeship is in corporate M&A, and
ah,
I do get a lot of paperwork and the bureaucratic
I'm
part.
sorry about that.
So later on, you moved to organized crime and international terrorism cases. How did it end up? Like, how did you get into it? What?
I think it happens quite organically. I moved from common law chambers where the barristers did lots of different types of law, and then I realized I was really probably a criminal advocate. So I then applied and moved to a specialist criminal chambers, which is now called 25 Bedford Row, which is one of London's big criminal chambers. And I moved there, and that's where it was then 3 Grayson Square. And then I took a pupillage with Mr. Rock Tensley, who was a very fine advocate, and he was the head of chambers. So I was lucky enough to spend my time learning from him. And often I would go to the Old Bailey with him, and I'd follow him to run the courts and learn and watch him. And it was a great experience.
But so it was because of him that you got
Well,
into
in
organized
that
crime.
chambers, because it was a specialist chambers, they only did defense crime. So it was all the cases, none of the cases were civil. It was only criminal cases. So you would end up doing more and more serious criminal cases. So you evolved or organically as a barrister, as you became more experienced, you were given responsibility for more serious cases. So whereas you started doing a shoplifting or a burglary, you moved on to organized crime, wage snatches, robberies, armed robberies, and then attempted murders, and so on. So it happened quite organically for me, and the clerks can see that as your experience increases, you're given more responsibility if you can handle it.
Of course. So I did see that a lot of your cases in your Lion Chambers profile, and I'm interested in like at least in four. The first one is one that R versus A, and others where you successfully defended a nobody murder case. I'm
Oh
interested
yes,
in
yes, yeah.
if you
That
remember the strategy, how it was.
yes. Well, then having I've been a few, two or three chambers in my over my 35-year career. It's quite common to move sometimes, as solicitors do. They move from firm to firm occasionally. I spent a long time in 25 Bedford Row. Then I went to 9 Bedford Row, which started to do a lot of international work. Then I moved to 10 years ago to Red Lion Chambers, where I'm currently practicing, which is a large London criminal chambers. And that nobody murder case was a while ago now, where basically I was being led, and literally, unfortunately, the the deceased, the only thing that they managed to find of the body was a thumb, which had been dropped by a bird onto a pavement in the street. But they managed to work out from the DNA or from the thumb, this belonged to a certain person who unfortunately had been tortured, and his some of his limbs were cut off. And that was a trial for about 1 month, where um, I think I gained a lot of experience in what's called cell site analysis. A lot of the serious and organized crime cases depend upon cell site communications analysis, because the prosecution often rely upon the alleged use of telephones, mobile telephones, to prove who was using a phone at a certain time to prove their case. In later life, when I went to The Hague, of course, the big case I started there with, which was the Middle Eastern case of Ayash and others, um, the assassination of Prime Minister Hariri. That case, in fact, was all about telecommunications. So it was all about cell site analysis.
Okay, so through the telephone IP address, the IP address, you would locate that person and you would put them in a certain place,
Well,
and
the
therefore,
prosecution would do two things. They would normally they try, and the first thing they try and do is they try and what's called attribute a phone to a particular person. So that would mean trying to prove that that particular person was the user of the telephone. And then they tried, if they successfully proved attribution, they would try and then prove that the phone was at a particular place at a particular time, etc., etc. And so if you're defending, often attribution is accepted, but sometimes it's not. So when you're defending, um, one of the best ways to defend these cases is when you have a phone to try and break the attribution, because if you break the attribution, you break the case. So if they cannot prove the attribution, um, they can't prove the case, because often the cases depend upon the prosecution proving an attribution of a phone to a person. And it's a very basic thing to do. So if you're defending, you've always got to remember the burden and standard of proof, and that they have to prove that that phone belonged to that person. So if they can do that, then that's good for them. But sometimes they can't.
okay, it's interesting, an interesting take. And after, like in 2000 from 2000 and 2002, you also defended an Afghan hijacker in the longest hostage siege in the UK history.
That was a very interesting case. In that case, it was, I think it was about 2000, year 2000, and it went for 2 years, the proceedings, where a number of barristers were asked to defend a group of Afghan hijackers who were accused of hijacking a big commercial airline from Afghanistan, which then flew on to Russia, and then from Russia, it was flown to Stansted Airport in England. And so there were about 8 defendants, and so each one had 2 barristers. I was for one called Abdul Gayer, and the trial lasted a long time. It went 3 months, and there was a retrial for another few months, and so the proceedings went for a long time. And they were accused of basically taking the plane by force with their friends and family, about 60 of them, and then literally leaving Afghanistan. As you know, it's a landlocked country, so they left the country, and their defense was that they were acting under duress. So their defense was that they were forced to do what they did, to take the plane with force, with arms and with force. And so the plane was hijacked, but the reality was, as became clear during the trial, that in fact these Afghan defendants were in fact they were members of a group called the Young Intellectuals of Afghanistan. They were a pro-democracy, pro-women group, and they were basically fighting against the Taliban, because at that time Afghanistan was being run by the Taliban. And so, unfortunately for these defendants, because they were targeted by the Taliban, they had to flee for their lives, because some of their friends had been arrested and tortured and killed. And literally, they were fleeing for their own lives. So they took away their friends and family and managed to get on a plane. And then they managed to persuade the pilot to fly away from Afghanistan to safety. And we ended up in England.
But tell me one thing: the England criminal courts is composed of a jury, right? How does it
Yes.
work specifically?
Well, yes, we have a jury system which we really enjoy, and the barristers really are very proud of our system, because basically we are judged by peers, not a professional judge. So basically 12 random people are selected from the electoral roll, men or women, and literally anybody could be picked as long as they're of a certain age and so forth. And so you go to court for a trial on, say, on the Monday, and say the trial's for 1 week, and you have a judge who's like the umpire overseeing the trial, making sure that the law is managed correctly, and the jury give the defendant a fair trial. And at the end of the day, when the evidence is finished, it will be for the jury, having had the summing up from the judge, to retire to consider what their verdict is. So they will make the decision on guilt or innocence. And in England, we have a system of burden of proof of prosecution have to prove the case beyond a reasonable doubt. So if the jury are sure, they should convict. If they're less than sure, they should acquit. It's as simple as that. But they make the decision. I know in some civil jurisdictions, obviously you have the Code Civil, and so often judges will decide. In England, we like our jury, so the jury system is a wonderful system, I think, and it worked well.
Do you think it's easier to navigate through to that system with having a jury, not having a judge deciding over the penalty, over the liability?
If a jury convicts somebody, if they convict a defendant, then the judge has the responsibility to listen to the mitigation and then sentence the defendant. So that's the judge's responsibility, to sentence the defendant if he is convicted. If he's acquitted, then he would be discharged and released. And so it's a heavy responsibility, and the lawyers and barristers and the solicitors and judges take it very seriously. But overall, when it comes to the facts, it's the jury who decide, not lawyers, not the judge. And so that's a big difference from the civil law system. So, but we like that. So we have a system which we call adversarial. So the lawyers, the counsel that learn the adversarial system basically learn how to prosecute the case, how to defend the case. And it's like two parties where you're engaged in conflict. One's trying to prove guilt, the other is trying to avoid guilt by demonstrating the evidence doesn't show guilt. Sometimes the defendants plead guilty, sometimes not guilty. If they plead guilty, then it's a question for the judge then to sentence the defendant. But if a defendant pleads not guilty, then the court will set a date for trial then there would be a trial, then it would be up to the jury to decide what to do.
And in England, do you use a lot of the plea bargain procedure, or?
Well, it's not called plea bargaining, but yes, on a day-to-day basis in the courts all over England, it's true to say sometimes there are negotiations between counsel, not in the formal way it's done in, for example, in America, but there are sometimes negotiations where a defendant might say, well, I will plead not guilty to that charge, but I might plead guilty to this charge. And so sometimes the prosecution are given invitations to consider lesser charges, which sometimes they accept and sometimes they don't accept. So, it depends on the prosecution. I'm sure it's the same in all countries where there are criminal cases where there's sometimes room for negotiation.
Yeah, I think even in civil courts and civil law countries, there's always room for a bit of negotiation.
Of course.
And even though normally it's the prosecutor needs to follow up all the charges, but there's always a space, and I think legislation is improving in that sense. And I would also wanted to see talk about the 53 million securities depot armed robbery in Kent,
Oh yes,
which
yeah. Well, that was
you.
a interesting case. I was there. I was asked to. I think I was a junior counsel then, and I was asked to assist a leading counsel on. It was an appeal. It was not a trial. It was called the Securitas armed robbery, and in that case, it was a. I think it's the largest armed robbery in the United Kingdom, or certainly in England, where we were asked to represent somebody on his appeal against sentence from the trial sentence. So he was given what was called an indeterminate sentence, and we considered that it should have been a determinative sentence, so a fixed sentence, not an unknown sentence. So, what's called an IPP, an indeterminate sentence, is something akin to a life sentence where there's no fixed date for release, for example. So we were arguing that, in fact, there should be a fixed sentence. So when we went to the Court of Appeal, the Court of Appeal eventually agreed that it should be a determinate sentence. But obviously, because it was the largest armed robbery in England, they wanted an indication from us as to the sort of category that we would submit it to be in. And I think we accepted or suggested it was in fact worth somewhere in the region of 30 years, which the court accepted. So the sentence was a determinate sentence of 30 years. So yes, that was what happened there.
How was it for you? And how was it for you to be involved in these kind of cases, big criminal proceedings, being the securities depot armed robbery or the Afghan hijacker?
No, they're fascinating, interesting cases, and all cases are different. It's very nice if you're a barrister to be able to do different cases with interesting factual situations, and the barristers are enthused by that. And obviously, it's better to do a case more interesting than not. So it's more challenging, more interesting, and more enjoyable. The standard cases where the facts are less interesting, obviously,
Yeah, obviously.
have their own effects.
And also another case that you defended is when principal accused of organizing Al Qaeda website and recruiting terrorists for the Pakistani terror camps.
Yes. So I moved, I think, from general crime into organized crime, and then I think from after the Afghan hijacking case, then tended to get instructed in international terrorism cases. So then I was then representing young individuals who were accused of various terrorism offences to do with either alleged material in their possession or some of their alleged conduct, putting together suicide missions or having an encyclopedic set of materials on terrorism literature. That was very interesting. And I remember sometimes the accused would be said to be following the guidance from Al-Qaeda. So I actually inspected in Scotland Yard the original Al-Qaeda manual on how to be a terrorist. And obviously it was a very serious case, and that was hard fought. And we then went on to contest quite a few cases in England for terrorism, international terrorism, so which involved different countries, sometimes Pakistan, Afghanistan. One case I did called the Ricin case was a very well-known terrorism case where a group of young men from the area of Algeria were accused of being an Al-Qaeda cell in London. This was at the time of the Iraq War, and they were alleged to be, my client was alleged to be in accommodation where effectively they were alleging there was a ricin factory, or ricin was being produced, which is a deadly poison, which can kill many people. And the defense case was there was no ricin at all. There was no ricin. It was a false allegation, an allegation that could not be proved. So it went to trial, and it was a long trial. The trial lasted, I think there were a number of 6 defendants. The trial lasted 8 months at the Old Bailey, and then the jury were in retirement for about 1 month. And fortunately, the jury found that, in fact, there was no ricin, and they found in the defense favor. So they were all acquitted.
And do you think that participating in these cases as a barrister and a criminal defense lawyer, barrister, impact in any way your life, the social idea of yourself, if it impacts or no?
I just, as a professional, I took them as just another case. Obviously, they're interesting cases, and they deserve a lot of professionalism and responsibility, but I just see them as cases. So it don't tend to affect me, certainly not individually. I just move from one case to the next. Okay. And trying to do the best as I can, as I'm sure would all lawyers will do the best they can. And so, but it did set me on a new path, because that led me, and these international terrorism cases basically gave me experience in something I hadn't done before, which was defending in terrorism. So there were a number of these sorts of cases until about 2010 or 2011, when I was asked to go to Holland, to The Hague, because they then told me there was an international court there called the Special Tribunal for Lebanon in The Hague, which was meant to be one of the world's first international terrorism courts. And a number of alleged Hezbollah operatives were eventually put on trial in absentia, so not in their presence, in their absence. And that was the world's first trial in absentia since, I think, the Second World War and the Martin Bormann case. So it was seen as the world's first in absentia trial. But that was a terrorism case, and I think without the domestic experience of terrorism, maybe I would not have been selected or invited to do that case in Holland. So it was useful from that point of view.
Could you explain a bit what was the Special Tribunal for Lebanon created for?
It was a court that was it was a bespoke court set up in The Hague in Holland, where all the international courts tend to be, and it was set up to try people who were being prosecuted for assassinating the Prime Minister of Lebanon, Mr. Rafik Hariri, who unfortunately was assassinated in Beirut in a while ago now. And he was assassinated when he was being driven to his palace from the parliament in Beirut along the coastal road. And unfortunately, whoever it was exploded, made an explosion of some 2 to 3 tons of TNT type explosive materials, which caused a massive explosion. It killed a number of people. And so 5 accused went on trial for assassinating the prime minister, who was killed. Mr. Hariri was killed in the explosion, and a number of other people. So about 20 people. Sorry.
The criminal procedure law was from Lebanon, so they used.
Yeah. Well, there was. We all had to be familiar with the law, the criminal law of Lebanon, and the codes of procedure from Lebanon, but the international court followed very much international adversarial type procedures. So it was like a common law adversarial case. It was prosecuted and defended. Each of the 5 accused had their own legal team to defend them, and from different countries around the world. So I was representing a young man called Assad Sabra from Lebanon, or I should say, I wasn't representing him. I was rather, unusually, I was representing the interests of the accused, because there were no physical accused. We were all representing the interests of the individual accused. And so we tried to defend their interests as best we could for that trial. And that trial started, the proceedings started in 2011. The trial started, I think, around about 2014, and it went 4.5 years. So it was a very long trial in front of judges from Lebanon.
During that time, do you went to the Hague?
Yes, I went to The Hague in 2011, and that was the first case I did in The Hague. So I was defending the interests of the accused from 2011. And that trial, I was told it would go 2 to 3 years. That's certainly what I told my wife and children. But in fact, the trial didn't finish until 2020. So it went 9 years, not 2 years. So yeah, I was living in The Hague for a long time, and yes, gained a lot of experience of that. Yeah.
And to note that the accused, Assad Sabra, was the only one that was acquitted from the Special Tribunal, right?
Well, he was the only one acquitted at the end of the proceedings. Okay. That's true, which was very fortunate, and I would say correct on the evidence. In fact, there were more acquittals by the trial court than that. I think there were 3 acquittals and 1 conviction. However, in The Hague, the system is that if one side loses a case, the other side can normally appeal. So in this case, there were acquittals for 2 other accused. But then once they were acquitted, the prosecution decided to appeal the acquittals. So their acquittals were appealed by the prosecution to the appeals chamber, who then found them to be guilty. So the acquittal was reversed. And uniquely, the prosecution in the Lebanon case decided not to try and appeal my acquittals. So my client was acquitted of all charges. Yes.
But what was the strategy behind, if you may?
Well, in that case, it was a telecommunications case. So the whole prosecution case was dependent upon cell site analysis, which we discussed earlier. So the whole theory and strategy depended upon their ability to prove that these 5 individuals were using certain mobile phones at certain places at certain times, and they constructed a theory around the mobile phone telephones. So defending, obviously, I looked at and because we had no instructions, in fact, I wasn't clear whether my client was alive or dead. We had no instructions. So in that sort of situation, which wasn't unusual for a barrister to have few instructions or no instructions, you basically then have to look at the evidence for the prosecution, analyze it, and decide how they're putting their case, then you have to decide how you would defend against the case. So I took the view their whole case depended upon attribution of a mobile phone. And so the objective in my team was I led a team of 12 to 15 lawyers for 9 years. I took the view the best strategy was to try to break the attribution theory, which we tried to do. So we spent years preparing the case and fighting the attribution to try and prove that the number which they alleged was attributed to a particular person, in fact, they couldn't prove the attribution. So we happily succeeded in breaking the attribution, hence the reason for the acquittal, I imagine. And in fact, more than that, we tried to break the attribution. We also tried, or I tried to put, in fact, another phone in the possession of the individual they were attributing one phone to. So we were suggesting that person had a different phone, not the phone that they relied upon. And they were relying upon the phone to prove, for example, that certain phones were being used in Beirut near where the Prime Minister was. So they were trying to suggest that Mr. Hariri was being followed from A to B to C, etc., and that a certain group were near where the TNT explosives were. And so when the bomb was detonated, they were again alleging that certain phones were in certain areas. So they were trying to connect the phones to the criminality, which often happens in national jurisdictions.
Did you have to go to Lebanon to do some research, or do you have the
Yes,
private?
yes,
Okay.
that's a good question. No, many times. So I would frequently have to go to, well, not frequently, but certainly once or twice a year, I would go to Lebanon. I'd investigate the crime scene, because even in 2011, which was many years after the explosion, there was still a huge crater, and you could still see the damage caused by this huge bomb, because it caused a massive damage. A number of people, sadly, were killed and injured. And so I would certainly investigate the case. I would look all over Lebanon, and in fact, I obviously in the case, as telecommunications were the most important feature, I actually asked to see the Minister of Telecommunications in Lebanon, and in fact, I met a number of individuals there to try and understand the telecommunications system in Lebanon. And we made various requests of Lebanon to assist us in that respect, in a way to try and understand how the phone networks worked, because that's very important to understanding how the prosecution put their case. So we would make requests as to which phones were where, what the phone evidence was, how the phone networks worked in Lebanon. And I personally went and met the Minister for Telecommunications for that purpose, to try and understand it better.
Were they cooperative,
Yeah, we
or?
had a lot of cooperation. Unfortunately, at one stage, I had to request the court to make the court's first order against the government, to seek their cooperation in relation to certain areas, and then we received incredibly good cooperation, and the results of the cooperation we could use then in court. So that often meant we would disclose documents as a result of receiving the order for cooperation, which we could use and deploy in the courtroom, because the material was given to us by the prosecution and by the government of Lebanon, who were very helpful in providing material so that the accused had a fair trial.
It's interesting that there's like I read that there was a unique aspect of the statute of the Special Tribunal for Lebanon, that the court allowed the retrial if any convicted individual tried in absentia rejected the verdict.
Yes, that's true. It's true that it's very unusual. So I think what you're talking about is a situation where, if, for example, somebody was convicted after a trial, where they weren't there. They were tried in absentia, and then say, for example, after the trial had finished, say an accused actually was found to be alive and was being arrested, it's possible under the rules that they could require a retrial. But as I understand it, none of the accused were ever arrested personally. And it was alleged that one of them, the main accused, who I don't name, was assassinated himself during the trial in Syria. But I had no contact with the client I was asked to represent, so I was acting for his interests. I really never knew whether he was live or dead. I just did the best I could with what I had.
It's yeah, and it was a success, yeah, for sure. And after this long period of time, what did you do?
Well, I should also say for younger lawyers, languages are important, and so I should have mentioned that in that court, one other thing that we had to get used to, as you do in an international court, is wearing headsets and languages, because the language of the court in England obviously is English, but in the international court in Lebanon, the language of the court were Arabic, French, and English. And one of my colleagues, Mr. Emil Aoun, in fact, addressed the court in 3 different languages. But normally, if you were speaking English, as I would tend to ask a question in English, which would then be, if it was to an Arabic witness, interpreted into Arabic simultaneously, as they've got very good interpreters there. Then the witness would answer the question in Arabic, and it's interpreted back into English for me. And that is how you work. And that in a sense, that's one of the reasons why these cases do take so long, because linguistically there are many challenges, and the court tries to get it right. And to
Don't you believe that with the different languages, something, even the question that you do that you make that you say to the witness, get lost a bit, like the tone, the idea behind it?
yes, you can certainly a lot can be lost in translation, and so for that reason, I tried myself to learn Arabic, which was not easy, and it was a complete failure. I tried, but I had many lessons in Arabic, and even to this day, I've still got very basic knowledge. But I would urge young lawyers to learn languages if they want to do international work, because it's a big advantage. And certainly, I found even with my basic knowledge of Arabic, it helped me understand a lot, for example, of the texts, because a lot of the evidence depended upon texts. And at the time, the keyboards on the texts for mobile phones weren't in Arabic, they were in English, or a mixture of English and Arabic. So you really needed to understand what phrases and words in Arabic could mean in English, or vice versa. And so I deployed a lot of linguistic experts in Arabic to teach me and explain to me, for example, what a particular sentence might mean, or did it have just one meaning, or were there other meanings? And sometimes I would be advised that a particular sentence could be interpreted in 3 or 4 different ways, whereas the prosecution might use one interpretation. It may well be there were other equally valid interpretations which had different meanings completely. So understanding languages can have a very beneficial effect upon a trial and help you a lot as a lawyer.
Yeah, unfortunately, my Arabic is also very basic, as my family is also Egyptian. I do know a bit, but not enough to for anything.
Well, there were Egyptian lawyers. There were some Egyptian lawyers in that case. It was an interesting. It was wonderful to work with different lawyers from different countries. So there were Lebanese lawyers working there. There were Americans, Canadians, French, Belgian, Egyptian, Tunisian. So it's a completely different legal culture, and you have to grasp it, understand it, and work within it. And it's good to cooperate with all those that you work with for the prosecution and defense. But I think that if you develop your language skills, that will help a great deal. In the International Criminal Court, obviously, there are many counsel on the list, probably over 600, but there are very few with Arabic skills, and it may well be in the next 5 to 10 years. Those who could speak Arabic will have a big advantage on the list of defense counsel, because there may well be uh, Arabic speaking accused in the International Criminal Court being prosecuted. We'll have to wait and see.
Exactly. And as it was a great segment because do you believe, from what we have seen, that, for example, Syria will become a member, a state party to the ICC, and therefore have them have the ICC prosecute the
Um,
Syrians?
uh, Honestly, obviously, I don't know. I'm a
Of course,
civil
of
lawyer.
course.
I don't know, but obviously, we know that the international prosecutor, Mr. Karim Khan, was recently in Syria. And obviously, given what's happened there, a lot of lawyers will be very interested to see whether accused from Syria will be going to The Hague. And the recently, we've also the prosecutor has also applied for arrest warrants in Afghanistan. He's already applied for the releasing of arrest warrants for a number of Libyan accused. So there could be Libyan accused, there may be Syrian accused. And so Arabic speaking counsel will have, certainly, in my view, a huge advantage. Certainly in your team, you would need to have, if you're defending Arabic speakers. And so in the Lebanon case, I made a point of making sure that I had Lebanon lawyers in my team, as well as other experts from England and international lawyers and jurists. And it's very important that you respect the language and that you have the local language lawyers, speakers working in the team.
But David, but how is it to manage and lead an international defense team? You said
That's a good
12 for
question.
15. Yeah.
Normally, as a barrister in England, you are working alone or with one or two others. So it's a new concept, and you have to get used to that, because if you're a barrister working in the international courts, you're not just a barrister. You're a barrister, you're a solicitor, you're an investigator, you're an analyst. You're doing lots of different tasks at one time. And so what I did was to put a team together of I had other lawyers to assist me who are brilliant drafters, writers, and because a lot of the litigation is conducted in writing, pre-trial and during the trial and after the trial. So you need lawyers who are great in court, as well as lawyers who are great with a pen, who can write or email rather. And so you need to build a team. In that case, in the Lebanon case, each of the accused had a team of about 12 to 15. So they were made up of a case manager, an assistant case manager. You had analysts, evidential reviewers. You had counsel, junior counsel, assistant counsel. And so it was quite a big team. So you have to get used to trying to manage people as well as yourself. So it's challenging.
Yeah, I imagine. Yeah, not only strategizing the case, but also managing all those
Yes,
15.
you have to try and do many things, multitask, but you have to be a good people manager, and you have to really work well with other people, because you're all relying upon each other. Each we all have different skill sets, so um, that's a good. But you have to have a very good team, and because the prosecution have had a team of over 60, I think, and they had many counsel. So we were against a large team.
Okay, so the quality of parties is not the same between the prosecution.
Well, I don't. Well, I can't comment on that. No, we were treated very well, and equality of arms is always an issue for a defence counsel, and you have to make sure that you have the adequate time and facilities to prepare your case, so that you're in a position to defend the interest of the accused or the accused as best you can, so that you have a fair trial. You're there to make sure you have a fair trial and do the best you can. That's what we did, and the case was prosecuted very fairly and properly, as I would expect, and we tried to do the same from our point of view.
So this case sets you up to be invited to lead the defense in the Kosovo Specialist
Yes.
Chambers,
Yes, that's right.
representing Mr. Recep Salimi.
Well, before then, that case went I should say, the first case went for 4.5 years, I think. And then the trial itself finished in about 2018. Then the judge retired to consider their verdict and deliberation. That took about a year. And then when that happened, when they effectively retired to consider their verdicts for a year, we didn't obviously know how long they were going to be. I was asked to, in fact, appear as amicus curiae counsel in another court in The Hague, which was the IRMCTY. Well, it was effectively the successor of the ICTY and dealt with the Balkans. So I can't say so much about this, but I was asked to investigate a war crimes case there, which I did for about 1 year. That was only a short case, relatively. And so I did that for 1 year, and I was reporting to a judge in The Hague. And then in September, I think it was about September 2020, the Lebanon court pronounced their decision and their verdicts. So they delivered their verdicts there. The verdict of the court, the trial, was it being a long trial, and that was in September 20. And then in November 20, I received a phone call and was invited to take on another case in another court called the Kosovo Specialist Chambers, which is another court in The Hague, which deals with Kosovo. And that case started in November 2020 and is currently ongoing. So I don't really, I can't really talk about that, if you don't mind. I'm not involved with that case now, but I was for 4 years. I don't really speak about that, please.
No, of course, it's ongoing. It's become ongoing cases. Okay, so after that case, you left on 2023, and now you are.
Well, then
back to...
I returned to England, to London, from The Hague, and I've been working. It's a quite strange feeling, back with my wig and gown on, as barristers wear wigs in the courts normally in England, and so I've been practicing in cases in England again with Red Line Chambers, going up and down the country, defending in different cases. It's difficult to get used to doing the national case again, having been away for so long. I only thought I'd be away for 2 years, maybe 3, certainly not 12. Yeah, I'm very much enjoy being back in national practice, although there are opportunities to maybe go back to The Hague. We'll have to see.
Certainly, your family is very happy that you are back in England.
That certainly is. It does take a toll on your family, because if you are married with children, it's not an easy experience where you're working in a foreign country. And so if you're defending somebody and you're working in a foreign country, obviously you have to discuss with your family whether they move to that country, sometimes for a long time, or whether you commute backwards and forwards from England to the Holland, which I did for a long, long time. So I was always at airports and train stations.
So to end the episode, I would want you to, if you may, give advice to young lawyers and that want to go to work in international criminal law,
certainly.
international criminal courts.
Well, certainly, I would. I'd certainly recommend that young lawyers who are interested in that area, they firstly do their homework, they do their research, and they look at the websites of the international courts, which you can learn a lot from. That's one thing. You learn a lot from that. You can also because all the international courts, they all have their own websites and they give very interesting information so you can learn about different situations. I would recommend also, if, for example, that you are interested in the work of the International Criminal Court, that you join or apply to join the ICBA, which is the Bar Association for ICC lawyers. The ICTY or IMCT have or had an association called ADC. Again, another very interesting international organization for international counsel, which people can join, students, I think, as well as practitioners. And also the IBA, International Bar Association, obviously does a lot of international work. So that's a very interesting association to look at. And they have many committees on different types of law, not just criminal, commercial, all sorts. And so you can learn a lot from that and from the court's websites. And no doubt your national jurisdiction would encourage you to do international law as well. It's not just about cases, because there are not many cases. There are a few courts and there are a few cases. So there's a lot of international work which could be done outside the courts, and the lawyers should look at that as well. And I would advise them, and for example, in a lot of international cases are now being prosecuted in national jurisdictions. And hence, a couple of years ago, when the International Bar had their annual conference, one of the sections or meetings was called, "Is the future of international law national?" Which is a very interesting question. And a lot of people would say the future of international law is national, because a lot of international cases are being prosecuted in national jurisdictions under what's called universal jurisdiction. I think that will increase steadily.
But would you say that it's best for newly lawyers to first get experience back at
Yes.
their own countries, and then
Absolutely, yes. You learn the skills of the advocate in your national jurisdiction. I think that's the best way. I mean, some people go straight to The Hague and apply for an internship or a position on a team, which you could do, or you could go and try and work in a prosecutor's office, learn a lot there by working as an employee in a prosecution office, doing international cases. Or the other way, which I think is a better way, is to develop your skills as an advocate in your national jurisdiction. So you have real life experience as a lawyer and you qualify as a lawyer in your national jurisdiction. Then you've got something to bring to the party because obviously when you're applying for an international case, the lawyer will want to know what value can you add to the team. And so the more experience you bring, the better. And I would also say linguistic skills are very important. I fortunately speak French, and that helps because certainly the defense office was very francophone at the time in Lebanon case, and the head of the Lebanon office was French. So being able to speak French certainly helped. And many people speak French in Holland. But in the courts, most of the courts are using the language of English.
Yeah.
So you bet it's good to learn different languages. And so in the Kosovo court, it's also probably a good idea to learn Albanian, because the languages are English, Albanian, Serbian. And so the more languages you can understand, the better you'll be assisted, I think.
Of course. David, thank you very much for coming to the podcast. It was a pleasure, a great conversation.
Thank you. Thank you, Louis. Thank you very much for inviting me.